Hello and welcome to the podcast. I'm Karen Weaver. Today we have two knowledgeable guests whose expertise is shaping how universities draft and negotiate NIL contracts with their athletes. First up, joining us is Paia LaPalombara, a partner at the Church Church Hittle Antrim law firm based near Indianapolis. She's a former Division I student athlete and a powerhouse strategist. Yes, you are. She has advised institutions on the House v. NCAA settlement to structuring NIL licensing agreements and managing complex compliance issues. Welcome to the podcast, Paia.
Thank you so much, Karen. Happy to be here and to see a fellow Quaker.
What sport did you play, by the way?
Rowing.
Excellent. Yeah. So you know the Schuylkill Navy and all that kind of stuff.
Very much so. A lot of time on this, not the cleanest river, but it's beautiful in the morning.
It's getting better. It really is. I promise you that. My other guest is Connor Glass, an associate attorney at CCH+A, same firm. Connor specializes in compliance, infractions, and gender equity reviews under Title IX. Connor, welcome to the podcast.
Thanks for having me, Karen. I'm excited to be here.
So we have a lot to talk about, but I want to kind of frame this conversation for our audience, which is mostly university leaders. Well, the world has shifted. We are now doing contracts with athletes that involve all kinds of things: name, image, and likeness, revenue sharing. So every university, Division I, that has opted into this settlement is now negotiating a whole host of legal challenges. So let's just start with the basics. What are the things that you see universities asking you both to do on a daily basis?
Yeah, great question. I feel like it's kind of a mix of all sorts of things. So for some schools, it starts at whether it makes sense to opt in, or whether it makes sense even just to wait a year, sort of see where the chips fall and then make that decision, or whether it makes more sense from a financial perspective to opt out. So what we're seeing, particularly with some smaller institutions, is it may not make the most sense fiscally for them to opt in because if a key revenue driver for the university is the admissions component or the roster sizes of your male and female sports, then by having those roster limits that are in place if you opt into the House settlement, then that may be tuition dollars that the institution had otherwise been anticipating. So that's been, at least for those institutions that are thinking to opt in or opt out, that's been a pretty big driver of that conversation. So that's sort of like the start is, do we even opt in? If they select A, yes, opt in, then it turns more to, okay, well, what does this mean for our institution? So are we going to be paying student athletes directly, or are we going to be relying on a third party, such as a multimedia rights company, even PayPal? Are we going to rely on another third party entity? Are we going to rely on a collective? Or as an institution, are we going to be making those payments? Or do we create a separate entity, a wholly owned subsidiary under the university to make those payments and potentially own those IP rights for the university? So that's sort of step two is, okay, we've made the decision to opt in. Now, how is that structure going to look at our institution? And then the third component is, okay, so what are we going to have our student athletes do? What is going to be the scope of their role when it comes to giving their NIL? Is it just going to be a passive licensing of their NIL rights, or is there going to be a more active component where you really want your student athlete to become an ambassador for the institution and play a more public-facing role from a university perspective? Or additionally, do you want to have more of the corporate involvement? Do you want to license and sub-license your student athletes NIL to a third party so that the institution can use that licensing money from an institutional perspective? So that's sort of like the start of it. Connor, I'm sure I've missed a ton there, but what are some of the other things we've been seeing since working with institutions through this?
Yeah, I think that was a really good summary of kind of, it started with a lot of whether or not schools should opt in or opt out and kind of how conferences should approach that issue as well. And then it kind of turned into, okay, now that we're opted in, what does this look like? And it's, whether we want to handle some of this stuff in-house or whether we want to keep our collectives alive and how do those parties and our boosters and our student athletes and our MMRs, how do all those third parties kind of interact together? I think another thing we do is just kind of boots on the ground day to day. Hey, these are the red lines that are coming from this student athlete's agent. Can you help us through the process of negotiating this? So a lot of it's kind of negotiating the contracts and kind of keeping lines of communication open with schools in terms of what are some areas that you're willing to negotiate and where do you want to draw more of a line in the sand that you're not willing to cross.
Yeah.
And then just other legal issues that kind of come up when you have an international student athlete and his or her agent are asking for specific things in the agreement, or agents are asking for specific things in their agreements. Schools are also asking about Title IX a lot and how they should be preparing for any complications that come regarding Title IX, or what can they do now to try to ensure that they're being as compliant as possible.
Okay, so I have a host of questions that I'm going to try to anticipate that others might have. First off, my understanding is just between 18 and 20% of the Division I schools did not opt in. So it's a large percentage of schools that have chosen to opt in. Do you have any sense as to why? Was it because they were short of the revenue side? They weren't quite sure where they were going to pull the dollars from? Or was it they didn't have the system set up yet? Any sense of why schools chose not to opt in?
Yeah, that's a great question. It's probably a mix of the two. So I think it was July 1st was the date, the final opt-in date. And even after July 1st, institutions are still figuring out structures and systems. We've been working with quite a few schools since July 1 who are still trying to really figure out that component. I think we have a couple of different things, even just thinking more holistically beyond athletics. There's a lot happening in higher ed at the moment. With everything from research funding to the enrollment cliff to still rebounding from COVID. There's just a lot of financial pressures that have been on institutions. And so I think a part of it is institutions wanting to take that breath to figure out, sort of what this new normal is going to look like, particularly if there's been some research funding changes and how that impacts the university, to then figure out, okay, well, how are we going to do this with athletics? Will we be that far behind competitively if we don't opt in this first year? And that allows us to sort of see whether this is something that would be productive for our university or not.
Yeah, that makes sense. I wondered oftentimes why more schools didn't take a breath in this situation, but I also heard from several presidents that said it was really an enrollment concern. We figured we needed to figure out our rosters of tuition-paying students first,
Yep.
and then figure out whether the roster cap was going to inhibit that. It was more of a roster cap issue than it was an NIL. Is that your understanding?
Yeah, the roster cap was definitely a huge component of it. I think there was a concern from a couple of sides. One, from a Title IX perspective of, if you're an institution that's been relying on prong one for your participation for however long, and then you have these artificial cuts that are now in place due to the House settlement, how that's going to balance your numbers for the upcoming year. So I think that's a concern. I do think some of that pressure had been alleviated by the new designated student athlete component that was introduced in the final settlement that was approved by Judge Wilkin, where now student athletes, if they were going to be cut because of the roster limits, now are considered designated student athletes for the entirety of their collegiate career, no matter which institution they're enrolled at. So that now that provides a little bit of a pressure release for those institutions. Those student athletes will still count from a Title IX perspective, but that again allows some more movement and some creativity for universities as they're navigating that. And I do know that is a reason that some universities ultimately did decide to opt in, is because there were those concerns about the roster cuts and how they were going to manage that. And that provided, again, that pressure release, at least for the short term, probably the next 2 to 3 to 4-ish academic years, where they can have some of those DSA student athletes.
Gotcha. Connor, let me ask you this. You see these contracts. Do the contracts come to you from the school that they're going to propose to the athlete and the agent? Or do the athletes and agents sit down with you and say, this is what we think we'd like to ask for, or both?
Yeah, I've negotiated and worked with clients on all sides of these agreements. We've helped conferences and institutions draft their own kind of form agreements that they can send over to the student athletes. I've worked with student athletes to review contracts that have been sent over by institutions, and we've worked with boosters and collectives and other third parties that want to offer their own NIL agreements, kind of separate from the institution with student athletes. So yeah, kind of navigated it from all different angles.
Do you find that to be challenging? I mean, I know that's sort of like a lawyer's job is to advocate for their client, but you've got to think about this from all these different perspectives. How do you balance that?
Well, I find it stressful, but I also find it very exciting. I'm a pretty new attorney. I've been at CCH+A for 2 years. And this kind of evolving space in college athletics is really exciting for someone like me who doesn't fully understand the way things used to be because I wasn't practicing law there. And now that we're kind of in this new changing landscape, I feel like it's somewhat of a level playing field. I obviously have a lot to learn about licensing agreements and IP, but I feel like if you can negotiate these on behalf of a student athlete, that means you can negotiate them better on behalf of the school and then better on behalf of the booster. So it's kind of seeing things that other people are pushing for and keeping an open mind to how that could be useful down the line when you're on the other end of the table.
Gotcha. Paia, well, talk to us a little bit about some sample contracts. I had a conversation on the podcast, my listeners might remember, with Michael Leroy, who's a University of Illinois law professor who had managed to get, through FOIA, copies of some of the initial conference-wide contracts. Does that idea still exist that the entire Big Ten, the entire SEC, will have a conference-wide standard agreement, or is this literally school by school, program by program?
I think we're going to see a mix, but primarily it has been school by school. So we have, I think that in terms of conference wide, I think that the Big Ten is more on the strict side of this is the agreement that we have, and as best as possible, this is the agreement that every institution within the Big Ten needs to follow. Whereas with other institutions or other conferences, there's a little bit more of the flexibility where it's here's a template agreement that we have. And if you want to use this agreement, then you absolutely can, but you're able to flex it and move it as you see fit.
Right.
So I think it's been a bit of a blend. But every school is different. I think one of the things that when we start working with institutions that we really want to figure out are what are your values and what are your ultimate goals, and help to draft and craft an agreement around what they're specifically looking for. I think every school has a different philosophy. We have public institutions, we have private institutions, we have religiously affiliated institutions, we have those who are not. And in addition to that, you have your publics and your privates and your some who have state laws and some who don't have state laws. So every school has its own unique sort of identifier or fingerprint. And so we want to make sure as much as possible that we're aligning with that. And I think for the most part, conferences have been flexible in allowing schools to see what's most important to them and to make sure that they're able to protect what it is most important or most valuable for that institution.
So what are the things that you're seeing are most valuable, most appreciated? Is it about staying and getting a degree? Is it about, having a contract that allows the athlete to have flexibility? They don't have to pay for a buyout. I mean, I'm thinking of the continuum here.
Yeah, I would say a big, and Connor, let me know if you're seeing something different with your clients, but a big part of the conversation has been around the liquidated damages, and whether or not that's something that an institution from a values perspective would want to enforce or protect. Right. Because if at the end of the day, you sort of think about what is the role of an institution, of a university or a college, and it's to support and grow young people into adults and help them to learn to be good thinkers and writers and creators and, move to that next phase of life prepared. And so a lot of that comes with learning. Like that's essentially the student conduct process is sort of a safe way to make small mistakes, but do so where you're getting some meaningful consequences, but consequences that are teaching you something along the way. And so if you think about it from that lens, and then you think about liquidated damages, or you think about whether a buyout clause makes sense, as an institution, you have to say, okay, well, do we want to be an institution that is going after an 18 or a 19-year-old student for wanting to go to another school as opposed to our school? And do we want to financially try to get some financial recompense for that? And I think that's going to be a challenge for some institutions, but that's been a big part of the conversation in terms of, what makes sense for us from a values perspective. Another one is just the scope of the grant of rights and whether a what an institution is going to want. Do they want an exclusive use of student athlete rights? Do they want to limit it from any sort of entities where the student athlete is not allowed to license their NIL to a specific unit or entity? Or, does the institution want the right to be able to sub-license it? And if so, does the student athlete get any additional compensation for that? So that's been another big one is, okay, what is the scope of what we're looking to do? And do we want our student athletes also to perform any services for us? But Connor, I'm sure, again, there's a lot here that we go through. Those are just sort of the two that I had thought of, but what are some of the things that you've seen?
Yeah, I think, the most important one, and this may be somewhat of a jaded answer, but it's always the money. I mean, it's always the first thing the athlete's checking, and the first thing their agent wants to see is how much are they getting paid and how are they getting paid? I think a lot of times it's in the agent's best interest that they get paid up front with a big lump sum, and then the agent can take their portion and then move on to the, negotiating their next contract. But for the school, it's really important to have contingencies in place, like Paia was mentioning, in the event that the contract is breached or the student athlete puts themselves in a position that doesn't reflect well upon the school. And I know the liquidated damages can be, a lot of schools are kind of split on whether they want this in the agreement or whether they'll enforce it. Another way to kind of approach that is through just scheduled payments. And hey, every month on the 15th of the month, you get paid X amount. And if you stay with the school and you stay in good standing and you stay academically and in some cases athletically eligible, you'll continue to get those payments. And if you breach this contract, then those payments will stop or at least be paused. And so, from the agent's perspective, sometimes they're not as agreeable to that. But I think for an institution, it's really a good way to kind of protect your brand and kind of keep something that is fair for the school, but also fair for the student athlete.
Yeah, and from that lens too, Connor, I think another component too is we've been talking a lot about from an employment perspective. If you're having consistent payments throughout the academic year, so again, not aligning it with the playing season, are you more preparing yourself for that against the pay for play argument that, the student athlete is an employee and they're being paid to play for the institution. And so that's where some of the creative component that we do is, again, agents are wanting front-loaded payments because they want the flexibility for the student athlete to be able to leave. But as an institution, you also have to have the hard decisions or hard conversations before you even begin the negotiation of, all right, what is our bat now? What is our best alternative to a negotiated agreement here? And where are we going to stand firm so that we're both protecting ourselves as an institution, but then also still being fair to the student athlete?
My understanding is that there is an underlying assumption that all of these disagreements, if they go anywhere, would go to arbitration. Do I have that right?
I think it's a mix. So for licensing agreements, some schools want to go through the traditional legal process. A lot have been doing arbitration though, just because it generally is a quicker and more discreet process.
Yeah.
But from a settlement perspective, then it has to go through the arbitration process if there's a disagreement over the range of compensation, or if there is an issue that arises when it comes to a potential violation of the rules that the CSC and the NCAA are creating. Connor, have you been, for the ones that you've been working with, are you mostly doing arbitration as well?
Yeah, a lot of sometimes schools want to put in sort of like internal mediation as a kind of the first dispute resolution process, and then arbitration as kind of a secondary option, and then some will want to pursue sort of legal action through the courts. I think with the NIL Go, it seems like there's kind of three options. You can, if you're not within the range of compensation, you can renegotiate your deal and then resubmit it. You can defer payments, or you can pursue arbitration.
All right, so this is a good segue to NIL Go. Some presidents may have heard that term, or they may have heard that there is this understanding that you have to file something above $600 with somebody somewhere. So, Connor, explain to us what NIL Go is.
Yeah, so NIL Go is it's a third party that reviews NIL agreements done outside of the institution. So institutional payments will not be subject to what other entities, such as like collectives, will be subject to under the House Settlement Agreement. And so the two things that NIL Go will be looking for is for a legitimate business purpose that the agreements are for, and that they're within what was originally called fair market value, but is now called within the range of compensation. So those are kind of the two things that NIL Go will be looking for. Early on, some of these collective agreements, a lot of these collective agreements were getting rejected because they weren't for a legitimate business purpose. Their purpose was raising money for the collective so that they could pay athletes. So while there was quid pro quo, they weren't paying the athletes for athletic achievements. They were paying them for, photograph sessions or autograph signing sessions. They didn't meet that. They didn't meet the legitimate business purpose because they weren't raising money for a business outside of the collective.
Okay, so if I'm a student athlete who's been asked to come to the local Boys and Girls Club to sign autographs, how does this NIL Go place determine what's fair or what's within the range of compensation?
So
I'll let you. I'll let you land. I think that's the $1 million question.
Yeah, good luck, right?
yeah. Let me just compute really quickly.
Yeah, that's a ChatGPT question, I think.
Exactly. Yeah, I think there's a number of factors that. So Deloitte is the creator of NIL Go that are being used to determine this range of compensation, which the artist formerly known as fair market value. And so those are sort of all put in. And I think what we're going to be seeing over the next 3 to 4 months now is what those factors are. I think you're going to be able to start drawing them out as people are negotiating agreements. If the agreements are getting denied, all right, well, what if I add institutional IP? Will that increase the value of the range of compensation for a student athlete? What if I increase the number of services by 4 or the social media post by 8? And I think that'll help people sort of calibrate where that is. But I think it's everything from market to position to sport to year in school to social media following. It really is going to be sort of a cross section of things that are being taken into account in other industries as well. So like I think one of the things we forget sometimes is like social media influencers have been around for quite a long time. This is the first time student athletes are in this role. But that's sort of, I think, a great sort of place or platform for individuals and campuses to look at is, okay, well, how has this been successful other places? What are these companies using when they are determining what an appropriate range of compensation is for a TikTok influencer who has 4.5 million followers? And sort of use the same sort of guidance as they're working through this with student athletes as well.
So how do I find out? I mean, if something gets rejected, do I have to rely on the media reporting it? How do I find out if I'm another school that somebody's been rejected?
Yeah, it's so for your own institution, the student athlete gets an email and the institution should be getting an email. I think the institution was not getting an email right at the beginning, but I do believe that has been fixed. So as an institution, you should have that. I think one thing that's great about college athletics is everyone really is we while competing on the field, there is still a lot of communication that's happening amongst athletics departments. So I think there will be quite a few probably correct anecdotes that are being shared and probably some that are incorrect. That are going to get everyone all fired up. But ultimately, I don't believe that the actual values or individual agreements, another institution will be able to see which of yours have been approved or denied. I think you would just have access to what your own institution is, and then you kind of have to rely on your range of contacts across the country to help to further refine your negotiating on campus.
Connor, that seems nuts. That seems absolutely nuts.
I would agree. You could also make the argument it's a good time to be a lawyer in this field because a lot of unknowns and a lot of things in place that don't quite make sense or don't quite seem fair. And I'm sure that they'll get more fair as lawsuits begin to happen and more arbitration takes place and some of these things get fleshed out a little bit.
So as a president, I can imagine I'm sitting here thinking, okay, so how many times this year am I going to get sued for this? And so I think it's a realistic question to say, how much of a budget do I need to set aside for these kinds of lawsuits? Have you had those kinds of conversations?
Absolutely, yes. Yeah, that's, I think, a big concern for not just athletics departments, but for presidents, for general counsels. A lot of the time at university, it's the litigation expenses or damages, those come from the general counsel's budget, and they sort of manage that process in conjunction with risk management as well, who oversees a lot of the insurance policies. But we've certainly had questions of, all right, well, what should be our litigation reserve at this point?
Yeah.
What should we be anticipating for this year? What should we be communicating with our insurance providers about what this change in college athletics is going to look like so that we can change our policy as needed?
I mean, this is in this era of higher education. Let's go back and go to the 30,000-foot view. To have this kind of uncertainty and unknown, not only with regards to how much it's going to take to recruit and retain athletes, but then also the unknown certainty of Title IX, and then this uncertainty of exactly how much of a legal fund do I need to have. How do you advise presidents to think about this with all the other outside influences that are impacting higher education?
Paia, I can weigh in with just kind of a general answer.
Yeah,
I think you'll probably be able to give more specifics, but I think it's, I think, these things have been evolving for a long time. House settlement, more so than we've ever seen, but even with NIL and before that, Alston, things continue to change, and people always want to have the best competitive advantage they can as early as possible. But I think a lot of times those efforts of being the first are kind of misguided. I think a lot of it is taking a deep breath and, hey, maybe we, even for smaller schools, hey, maybe we don't opt in this year and we take a look and see what the landscape looks like and get positions in place and processes fleshed out and figure out and tie it all back to things that guide our institution, university wide. And then maybe we opt in next year. And I think people wanted to be the first with NIL. And I think now people want to be the first with the House settlement, and they want to circumvent the cap and there's got to be a shortcut. And, I think some schools have the means to do that. And I think others should focus less on being competitive right now and think more so about being competitive 5 or 10 years down the line. So I think a big piece of advice is just kind of taking a deep breath and figuring out a game plan before you dive in without knowing what you're doing.
Yeah, absolutely. I agree with everything Connor said. I think a deep breath is needed, but is also hard in athletics. I mean, when you get a lot of people in athletics it's a competitive industry. And so you want to be the best and you want to be in the front. which is hard to balance with, all right, let's just make sure that we have a full understanding of what this is going to change for our university. But I think from a president's lens too, it's in a board's lens, it's important to remember the benefits that athletics provide to the university as well. And there are so many beyond just if revenue dollars are a part of it. Not that many institutions actually generate revenue for their university. It's a pretty small number. And so just remembering all of the other things, the student athlete or the student experience of coming to campus and seeing, having the opportunity to go to games and connect with other students on campus, the retention of students on campus, the admissions, that the bringing in of tuition dollars, the ability for those student athletes to connect with their institution in a way that maybe some students haven't, which will make them potentially want to come back and support the university financially at a later point. So there's so many wonderful things about athletics and about student athletes too. I think we've somewhat lost just the magic that is college sports. When you just think about it, I mean, every day we're thinking about it from like more of a fiscal and a risk perspective, but let's think about it also from this is an opportunity maybe for a student who would not otherwise be able to go to college to be able to go to college and maybe able to not have to take out as many loans as they otherwise would have, be able to receive a degree and go on and do wonderful things in this world. And that's the majority of student athletes aren't competing at a professional level at that next step. So what can we do for that 4 or 5 years to really set them up for financial success for their futures?
Well, and many of them believe that this is an opportunity to get life-changing money now. In fact, we've seen that in women's basketball. There's been an incentive to stay in college versus going to the WNBA. Now, that might change with the next collective bargaining agreement. We'll see.
Yeah.
But I think you bring up a good point. There's one other thing that you guys mentioned earlier that I want to make sure we don't ignore, and that's the IP rights that these contracts bring up. Explain to the audience what that means and what, institutions and athletes are looking at.
Yeah, so from an intellectual property perspective, you have your student athlete has what we usually commonly refer to as their NIL rights. So they have their name, their image, and their likeness. And the student athletes have the ability to do with that whatever they want. And so if they go into an agreement with an institution, they can either give an exclusive or a non-exclusive license to that university to be able to use the student athlete's NIL rights. So it's essentially saying, in exchange for a certain amount of money, I'm granting you the ability, you university, the ability to use my NIL in a way that makes sense to you. And a lot of agents are negotiating that. So what the university can actually do with those rights. But it provides that grant. If it's an exclusive grant, that means that the student athlete cannot grant those rights to anyone else. It is purely with the university. Those are very rare. It is mostly a non-exclusive right where the student athlete still has the ability to also, go out to a pizza place or go to a car dealership or go to another national company and individually license their NIL rights to that company, provided they go through all of the university processes, disclose it in NIL Go and things like that. And then the student athletes then have, or the institution then has those NIL rights, and sometimes they want to use them, maybe they won't want to use them. A big component is figuring out how long they get to use those rights for. What is the extent to which they can use them if a student athlete transfers or once they've exhausted their eligibility. So a lot of it can kind of mirror how a collective bargaining agreement works with what you'll see with the NFLPA or the WNBPA or things along those lines. But it's sort of like a finite good that you can use for a limited period. You could extend for a long period, but it essentially allows the institution to sort of package it and use those NIL rights as they see fit. And then there's the sub-licensing component too, where does the student athlete grant the university the right to then not only use the student athlete's NIL rights, but also let other companies use those rights too.
Yeah.
And that's where there's been a lot of action recently is the sub-licensing. And a lot of that is going through the multimedia rights company for the university, where they are sub-licensing it to other corporate partners to sort of create that university synergy where, let's say, like I'm in Ohio right now. So Kroger is like our big grocery store. So if Kroger is a partner of a university in Ohio, and then that university sublicenses the student athlete's NIL rights to Kroger, well, then you're seeing the student athlete affiliated with Kroger, the university affiliated with Kroger. And so then you sort of have this synergy across your department and your university. And so there's some free advertising for Kroger right there.
That is a whole nother topic we're going to have on another podcast, because I'm so interested in this space. And one reason is a few months ago, I wrote an article for Forbes about the fact that the NCAA released all of its back video going way back to the beginning of the association, where they available to use for anybody who wants to use it. And boy, you can make a ton of money off of that, just picking and choosing your clips.
Mm-hmm.
So I can't imagine that schools that have long athletic traditions, like many of the schools in the Big Ten, wouldn't want to do that. But the athletes who are playing in those films must have some rights, or maybe they don't. I don't know. But that's a topic for another podcast. Connor, Paia, thank you both so much. This was incredibly informative.
Thank you so much. We appreciated being here.
Yeah, thank you. This was a blast. Appreciate being on.
We'll do it again.
Sounds great. Thank you.